Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. We are moving on to the 34th lecture, that is, with respect to the professional ethics are concerned. So, before going to the topic, it is our regular practice that we recite the preamble of the Constitution of India to praise our founding fathers, their aim and goal, what they had towards our nation. So their vision is our mission. So therefore, let us recite preamble with a sense of sentiment and commitment, with a feeling that it is our goal and preamble our soul. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Let it be our everyday prayer. So, what is the topic for today? And we generally frame the topic in such a way, asking questions. If anybody look at it, his mind will start thinking, what is the question that sir is trying to ask? The question is, what is the degree of proof required in disciplinary proceedings initiated by the Bar Council of India? Let us understand this, dear friends. What is the standard of proof? See, we are talking about the professional ethics. And Advocates Act deals with what are the standards to be maintained by the advocates, because our profession is not a business or a trade. It is still considered to be a noble profession. It is a learned profession. And primary source is not the money. Primary is to render service, to wipe the tears by rendering service. That is why our Honorable Chief Justice of India, Honorable Chief Justice Sanjeev Khanna, my Lord, when 356 Advocate on Records applications were placed before my Lords, they have said Advocate on Records is a privilege, as well as you can also be made accountable. You are an officer of the court, of the apex court. Therefore, you can work one for your kitchen and one for your society. What does it mean? For your livelihood, you can take up your cases. But at the same time, you should also take up the cases for providing pro bono services to your clients. Get empaneled in the legal aid and render services. That is why my Lord has said one for kitchen, one for society. So therefore, what does it signify? It signifies it is a service-oriented profession. So there are standards to be maintained. Bar Council of India rule says advocate's duty towards the court, client, colleagues, and you should live up to those standards. And those standards should not remain in the rule book. It should be in your conscience, in your heart, in your blood, because there is no private affair or a public affair for an advocate. Advocate remains as an advocate throughout his lifetime. So therefore, in the capacity, in my personal capacity, I did, but not in my professional capacity. We cannot plead that, because advocate means he is considered to be a leading member in the society, a privileged member in the society. So therefore, whatever we hold the degree, we have to live up to those standards. But to make delinquent advocate, an advocate who indulges in the misconduct, there should be some fear of consequences also. Therefore, Section 35 of the Advocates Act says that when you are indulging in the misconduct, depending upon your misconduct, whether there should be a reprimand. Reprimand means warning. Don't do this again. This is the first and last time. That is reprimand. Suspension for 3 months or 6 months or 2 years. It depends upon the gravity of your misconduct. Or your conduct is such a way that you can never be an advocate. Therefore, remove him from the role. Chapter closed. So this is the fear instilled in the minds of every advocate to remind them that there is a Section 35 is there. Contempt of court is there. So therefore, be within the Lakshman Rekha. Don't cross it. Don't exceed it to invite Ravana. So this is what the professional conduct says. Now, once there is a complaint made by the client in the disciplinary committee of the concerned state bar council where you have got enrolled, complaint is received, notice is issued to the other side, that is the advocate. Now, to what extent? Now we are coming to the crux, to the topic. What is the standard of proof we need to, that has to be followed by the disciplinary committee of the state bar council or bar council of India? For this, you must understand what is the standard of proof in civil case, what is the standard of proof in criminal case, and what is the standard of proof with respect to the disciplinary committee cases. In civil cases, dear friends, ultimately where we are deriving at, see, one of the Honorable High Court, Delhi High Court judges has said, this is very, very pertinent and important to the topic. Trial is going on, but the learned judge makes an observation. It is not the parties or a trial, because one party knows what has happened, another party also knows what has happened. But who is at the trial? The honorable judges are at the trial, because they may not be knowing what has happened in their life. Wife says, husband is earning 2 lakhs, therefore grant me 50,000 as maintenance. Husband says, I'm unemployed for last 2 years. Where is the question of making maintenance? But who is at trial now? Honorable Family Court is at trial to find out. Therefore, in Rajneesh versus Neha case, affidavit, file an affidavit. When wife wants to claim, she increases the income of the husband. When husband wants to pay the maintenance, he reduces, as if he claims that he is a very poor man, though he may be a prince. So therefore, the Honorable Supreme Court has held, file an affidavit, disclosure of assets and liabilities. Therefore, we will make you accountable. We will punish you for false evidence. We will take action for the contempt. Therefore, that is the present position, dear friends. Now, standard of proof in civil case is one who asserts, one who makes the averment must prove. For example, a plaintiff files a suit for declaration that plaintiff seeks a declaration that he is the owner of, say, A property. Defendant says, that he is not the owner of the property. So what is the standard of proof? The plaintiff says that he is the owner, then where is the registered sale deed? Or where is your adverse possession? The court accepts only when there is in black and white, and court accepts the arguments made by black and white uniform. So everything has to be in black and white, dear friends. So therefore, if the plaintiff fails to prove that he is the owner of the property, then the matter will be dismissed, because one who asserts the burden of proof is not discharged by the plaintiff. There is a preponderance of probability. So standard of proof is one who asserts must prove his case. Assuming that defendant does not come, plaintiff has filed a suit for declaration that he is the owner of the property. Defendant does not come, it was made ex parte. What is the effect of it thereafter? Nobody is objecting. Nobody is there to object. Whether the honorable trial court can close its eyes and pass a decree and a judgment in favor of the plaintiff? The answer is no. The trial court has to satisfy its conscience whether the plaintiff has proved his case or not. But it is not the case of beyond the reasonable doubt like criminal cases, dear friends. You must satisfy to the extent where the court is convinced. Now coming to the criminal cases, the criminal jurisprudence takes the presumption that everybody is innocent unless and until the prosecution proves its case beyond reasonable doubt. Moreover, if there is any benefit of doubt, that will be given to the accused. My learned associate Mr. Sanjay Kumar Upadhyaya sir has said, what is the effect of this? The effect is, why in criminal cases it is beyond reasonable doubt, but in civil cases only the standard of proof is lesser, preponderance. Why? Reason is the consequence is very less, not penal in nature in civil cases. He may lose the property, but in criminal cases he may lose his life. He may lose his important, vital personal liberty, and he will be put behind the bars, maybe for life sentence. So consequences are more. So therefore, even the benefit of doubt can be given to the accused. But now where we stand with respect to the disciplinary proceedings are concerned. Dear friends, one of the latest judgments which I am going to deal with, that is, please note down, 2017 Volume 5 Supreme Court Cases 755. 2017 Volume 5 Supreme Court Cases 755. The name of the case is T.A. Kadiru Kunju versus Jacob Madai and another. T.A. Kadir Kunju versus Jacob Madai and another. This is a judgment authored by Honorable Justice Deepak Mishra ji, but the combination with Honorable Justice R. Bhanumati. What is the issue in this case, dear friends? Here, the complainant is Jacob. T.A. Kadiru is an advocate. So Jacob has engaged Mr. Kadiru, and I will say as complainant and the advocate. So Jacob has engaged an advocate, Kadiru, for what? For filing a divorce petition against Jacob's wife. Jacob wanted to file a divorce case against his wife. So advocate has filed a divorce petition. Thereafter, what happened? During the pendency of the divorce petition, wife died because of kidney failure. She has died. Now, Advocate Kadiruji has advised his client, you have filed a divorce case. Now your wife has died because of kidney failure. Therefore, there is nothing survives in the divorce petition. In the meantime, client Jacob has engaged our advocate Kadiru that, sir, there is a check dishonor case. There is a separate check dishonor case issued by one Ramachandran that was dishonored. So I request you to file a complaint under 138 of Negotiable Instrument Act. But advocate did not prefer complaint under 138. On the contrary, he filed a private complaint before the magistrate court for the offence committed under section 420 IPC. Under 156 clause 3, the criminal court has ordered for the investigation, and investigation is going on. Now the question is, where is that dishonored check? According to the client, he says that I handed over the dishonored check to the advocate. Advocate did not return to me. I am called by the police for investigation to show the dishonored check, but it is not with me. And advocate hand in glove with Mr. Ramachandran. Mr. Ramachandran, and he had received rupees 10,000 rupees from Ramachandran. So therefore, he is depriving from getting justice. Therefore, I am not able to cooperate with the investigation. Therefore, he filed a complaint with the State Bar Council of Kerala. Complaint was registered on the ground non-return of the dishonored check. Thereby, he is deprived from cooperating with the investigation. And advocate had received rupees 10,000 from opponent Ramachandran. Therefore, it is a gross professional misconduct. That is the complaint. Now, once it is filed, it has to be disposed of within 1 year. Otherwise, section 36B of the Advocates Act, which says automatically it will get transferred to Bar Council of India. Now, matter has gone to the Bar Council of India. The transferred case number 138 of 2005. Matter pertaining to 138, check dishonor case. It is purely a coincidence. But in the Bar Council of India, they have found the advocate of gross professional misconduct. So what is the punishment? They have found him guilty. Then what is the punishment? Punishment is reprimanding him, giving a warning to advocate not to indulge in gross negligence like this. And then asking an advocate to pay rupees 5,000 to the complainant. Thereafter, again asking the advocate to deposit rupees 5,000 with the Bar Council. If he has failed to deposit or make a payment to the opponent, complainant, then within a particular time, otherwise he will be suspended from practice for 6 months. So these are all the consequences, these are all these punishments imposed on an advocate. Now advocate is aggrieved. He prefers an appeal, a statutory appeal, dear friends, not specially petition. Statutory appeal under section 38 of the Advocates Act. He prefers. Now before the Honorable Supreme Court, he makes a submission. Advocate makes a submission that I have already handed over the check to the police officers. I don't have any check. Moreover, he gave me many other checks. I have handed over some of the checks to the client also. But advocate is not aware what are the checks that he has handed over to the police, what are the checks that he has handed over to the client. Generally, we as an advocate, whenever we give him, we get an acknowledgement. Here, the fault with an advocate is he did not get the acknowledgement also. So, now the question before the Honorable Supreme Court is this: whether not getting the acknowledgement, will it amount to gross negligence or it is only a negligence? The Honorable Supreme Court has held it is only a negligence. He has to be very careful while giving what are the checks that has to be handed over, and acknowledgement also he must get it. But having not done, he has not committed gross negligence, but he has committed a negligence. So therefore, the order passed by the Bar Council of India was set aside, meaning thereby he was not found guilty of professional misconduct, and reprimand was also set aside, punishment was also set aside. But whatever rupees 5,000 he has paid to the client, that will not be recovered, refunded by the complainant. But what 5,000 he has deposited with the Bar Council of India, that will be given back to him, refunded. But here the question is standard of proof. This is the story of the facts. Standard of proof, they are saying, dear friends, let me read that. It is more than a civil case, less than a criminal case. Let me take you to the relevant portion, dear friends, and that is the answer to our query. Para number 14 of the judgment. There can be no doubt that nobility, sanctity, see the words used by our learned judges. There can be no doubt that nobility, sanctity, and ethicality of the profession has to be kept uppermost in the mind of an advocate. Keeping that primary principle in view, his conduct has to be weighed. There, the approach of appreciating the evidence brought on record and the yardstick to be applied become quite relevant. A three-judge bench in P.D. Khandelkar, while dealing with the scope of an appeal preferred under Section 38 of the Act, ruled that in an appeal under Section 38, this court, in a general rule, cannot interfere with the concurrent findings of fact by the Disciplinary Committee of the Bar Council of India and State Bar Council unless the finding is based on no evidence or it proceeds on mere conjectures and surmises. This is very important, dear friends. This is heart and soul of our lecture. The court has further laid down that finding in such disciplinary proceedings must be sustained by a higher degree of proof, standard of proof. What sort of proof? Higher degree of proof than that required in civil suits, yet falling short of the proof required to sustain a conviction in a criminal prosecution, and there should be a convincing preponderance of evidence. So preponderance of evidence, it is before the trial court also, but convincing preponderance of evidence, we must immediately note with profit that the said principle is absolutely significant. The court has stressed upon the rule to be applied for acceptance or treating the finding defensible by the disciplinary committee of the Bar Council. Now, dealing with everything, dear friends, now para 17 is the conclusion. On a studied scrutiny of the evidence in this context, the factual score, the act of the present appellant cannot be treated to be in the realm of gross negligence. It will not fall under gross negligence. It would be only of negligence. The tenor of the impugned order, as we notice, puts the blame on the appellant, that is on the advocate, on the foundation that he has not received the acknowledgement. He has offered an explanation, advocate has offered an explanation that he had given the check to the police. There has been no delineation in that regard. That apart, there is no clear-cut analysis and deliberation on gross negligence by the advocate. The disciplinary committee found the appellant guilty of gross negligence as he had failed to get the acknowledgement from the respondent complainant. The examples given by the Constitution bench are of different nature. In the obtaining factual matrix, therefore, we are unable to accept the conclusion arrived at by the disciplinary authority of the Bar Council of India that the negligence is gross. Hence, we are impelled not to accept the submission advanced by the learned counsel for the respondent. Thereby, set aside the order on suggestion being made by Sanjay Parikh, learned counsel for the appellant, agreed that the amount paid to the complainant need not be refunded. The amount that has been deposited with the Bar Council of India shall be refunded by the Bar Council of India. There shall be no order as to cost. So in this case, the message is, the standard of proof is, it is more than a civil case but less than a criminal case. This is 2017 judgment, dear friends. But one more thing, it's a matter of caution. As a note of caution, there are views expressed by the Honorable Supreme Court with reference to the standard of proof, that they have said that standard of proof with respect to the disciplinary proceedings are like a quasi-criminal in nature. Therefore, the complainant has to prove beyond reasonable doubt. So in this case, we find something more than a civil case, less than a criminal case. This is 2017. But before that, there are few judgments which says it is like a quasi-criminal in nature, that is disciplinary proceedings initiated against an advocate by the Bar Council. Therefore, the complainant before the disciplinary committee must prove beyond reasonable doubt. So that is what they have held. So I will leave it to your wisdom. And there is a Tirukural, dear friends. Epporul yar yar vai ketpinum apporul meiporul kanbadarivu. What does it mean? This is a Tirukural. It means whatever you, this is a disclaimer to the speaker. Whatever you hear, whatever you see, whatever you listen, don't take it as a gospel truth. Analyze it, examine it, investigate it, and then come to your own conclusion. Your wisdom will always prevail over other wisdom. So you are the master. That is most important, dear friends. Thank you so much. I am deeply honored by presenting this lecture.